Namaskar. In this video series on the refresher training manual for execution matters for the staff of district courts at Punjab, Haryana and UT Chandigarh, we shall be taking up part 3 of chapter 4, in which we shall look into execution of decree by way of attachment. We will look into certain aspects of attachment of salary or allowances of servant of the government or servant of railway company or local authority, as well as of attachment of property. So let me take you to the said part of chapter 4. Execution of decree by way of attachment. Attachment of salary or allowances of servant of the government or servant of railway company or local authority. Order 21, Rule 48, CPC. On the order of the attachment of the salary or allowances of a government employee or an employee of a railway company or local authority or an employee of a corporation engaged in any trade or industry established by a central or state government, the salary or allowances have to be attached subject to provisions of section 60 CPC. In pursuance of the said order, Elmad or execution clerk shall issue warrant of attachment of salary addressing the authority in case of government employee as per following table on Proforma 19, Appendix E, CPC. Order 21, Rule 48, CPC. For Proforma number 19, order to attach salary of public officer or servant of railway company or local authority. Order 21, Rule 48. So in the title, we have to give the title of the case. Here we have to write the name of the person to whom this order is referred to. So it says, whereas dash, the name of the judgment debtor in the above mentioned named case is a described office of judgment debtor. We have to mention the office of the judgment debtor where the judgment debtor is working, receiving his salary or allowances at your hands, and whereas dash, the name of the decree holder in the said case has applied in this court for the attachment of the salary or allowances of the said dash, the name of the judgment debtor, to the extent of dash, the amount which is due against the judgment debtor due to him under the decree, you are hereby required to withhold the said sum of dash, the amount which we are asking the authority to withhold of the judgment debtor from the salary of the said dash. Here in this dash, we have to write the name of the judgment debtor in monthly installments of dash. Here we have to write the number of monthly installments that the court is fixing and to remit the said sum or monthly installments to this court given under my hand and the seal of the court this dash day of dash. So here the date is to be given on which this order is issued by the court, and here we will affix the signature of the judge. The central government has appointed that following officers to whom notices of orders attaching the salaries and allowances of the officers specified in the corresponding entries in column 2 of the table shall be sent. So if we can see, there are two columns. First column gives us the particulars of the officers to whom the above mentioned notice is to be sent, and in the next column it gives us the particulars of the officers whose salaries and allowances are attached. So for example, if officers who are working with Ministry of Finance, Defence, gazetted officers, then the above said order is to be sent to Accountant General, Central Revenues, New Delhi. For non-gazetted officers, the note order is to be sent to Assistant Financial Advisor, Establishment, Ministry of Finance, Defence, New Delhi. Office of the Controller General of Defence Accounts, New Delhi, gazetted and non-gazetted officers. For that, order is to be sent to the Controller General of Defence Accounts, New Delhi. Then Organization of the Controller of Defence Accounts, Eastern Command, Meerut, gazetted and non-gazetted officers. The order is to be sent to Controller of Defence Account, Eastern Command, Meerut. Then for organization of the Controller of Defence Accounts, Western Command Meerut, gazetted and non-gazetted officers, the order is to be sent to Controller of Defence Accounts, Western Command Meerut. For organization of the Controller of Defence Account Officers, Southern Command Pune, gazetted or non-gazetted officers, the order is to be sent to Controller of Defence Account, Southern Command Pune. For the organization of the Joint Controller of Defence Accounts, Patna, gazetted or non-gazetted officers, the order is to be sent to Joint Controller of Defence Accounts, Patna. For the gazetted or non-gazetted officers belonging to organization of the Controller of Defence Accounts, other ranks, the order is to be sent to Controller of Defence Accounts, other ranks, Secunderabad. For the gazetted or non-gazetted officers belonging to organization of the Controller of Defence Accounts Officers, Pune, the order is to be sent to Controller of Defence Accounts Officers, Pune. For the gazetted or non-gazetted officers belonging to the organization of the Controller of Defence Accounts Pension, Allahabad, the order is to be sent to Controller of Defence Accounts Pension, Allahabad. For the gazetted or non-gazetted officers belonging to organization of the Controller of Defence Accounts Factories, Calcutta, the above mentioned order is to be sent to Controller of Defence Accounts Factories, Calcutta. For the officers belonging to organization of the Controller of Defence Accounts Air Force, Dehradun, the above mentioned order is to be sent to Controller of Defence Accounts Air Force, Dehradun. For the gazetted or non-gazetted officers belonging to the organization of the Controller of Defence Accounts Navy, Bombay, the order is to be sent to Controller of Defence Accounts Navy, Bombay. So after the issuance of the order and getting it signed by the judge, the Ahmed or execution clerk shall enter the same in the dispatch register and hand it over to the Nazir against the proper receipt. The Nazir thereafter shall hand it over to bailiff, who will further get it executed and return the same. Now coming to the attachment of property. Attachment section 60 to 64 and order 21 rules 41 to 57 CPC, section 141 Punjab Land Revenue Act and volume 1 chapter 12 part H of rules and orders. The property liable to attachment or attachment and sale, a list has been given: houses or other buildings, goods, money, banknotes, checks, bills of exchange, hundis, promissory notes, government securities, bonds or other securities for money, debts, shares in corporation, all other saleable property, movable or immovable, belonging to the judgment debtor or over which he has a disposing power. The properties not liable for attachment or sale are the necessary wearing apparel, cooking vessels, beds and bedding of the judgment debtor, his wife and children, and such personal ornaments as in accordance with religious usage cannot be parted with by any woman. Tools of artisans, and where the judgment debtor is an agriculturist, his implements of husbandry, and such cattle and seed grain as may, in the opinion of the court, be necessary to enable him to earn his livelihood as such, and such portion of agricultural produce or any of the class of agricultural produce may have been declared to be free from liability under the provisions of the next following section. Houses and other buildings with the materials and the sites thereof and the land immediately appurtenant thereto and necessary for their enjoyment belonging to an agriculturist or laborer or a domestic servant and not proved by the decree holder to have been let out on rent or lent to persons other than his father, mother, wife, daughter-in-law, brother, sister or other dependents or left vacant for a period of 1 year or more. Milch animals, whether in milk or in calf, kids, animals used for the purpose of transport of draught, cart and open spaces or enclosures belonging to an agriculturist and required for use in case of need for tying cattle, parking carts or stacking fodder or manure. One main residential house and other buildings attached to it with the material and the sites thereof and the land immediately appurtenant thereto and necessary for their enjoyment belonging to a judgment debtor other than an agriculturist and occupied by him, provided that the protection afforded by this clause shall not extend to any property specifically charged with the debt sought to be recovered. Amended in the states of Punjab and Haryana, White Punjab Relief of Indebtedness Act 07 of 1934, Section 35 as amended by Punjab Acts 12 of 1940, 6 of 1942 and 14 of 1960 with effect from 30th of December 1960. Books of accounts, a mere right to sue for damages, any right of personal service, stipends and gratuities allowed to pensioners of the government or of a local authority or of any other employer or payable out of any service family pension fund notified in the official gazette by the central government or the state government in this behalf, and political pension. The wages of laborers and domestic servants, whether payable in money or in kind. Salary to the extent of the first 1000 rupees and one half of the remainder in execution of any decree other than a decree for maintenance, provided that where any part of such portion of the salary and is liable to attachment has been under attachment, whether continuously or intermittently for a total period of 24 months, such portion shall be exempted from attachment until the expiry of a further period of 12 months, and where such attachment has been made in execution of one and the same decree, shall after the attachment has continued for a total period of 24 months be finally exempt from attachment and execution of that decree. 1/3 of the salary and execution of any decree for maintenance, the pay and allowance of persons to whom the Air Force Act 1950, 45 of 1950, or the Army Act 1950, 46 of 1950, or the Navy Act 1957, 62 of 1957 applies. All compulsory deposits and other sums in or derived from any fund to which the Provident Funds Act 1925, 19 of 1925 for the time being applies insofar as they are declared by the said act not to be liable to attachment. All deposits and other sums in or derived from any fund to which the Public Provident Fund Act 1968, 23 of 1968 for the time being applies insofar as they are declared by the said act as not to be liable to attachment. All monies payable under the policy of insurance on the life of the judgment debtor, the interest of lessee of a residential building to which the provisions of law for the time being enforced relating to control of rents and accommodation apply, any allowance forming part of the emoluments of any servant of the government or of any servant of a railway company or local authority which the appropriate government may by notification in the official gazette declare to be exempt from attachment, and any subsistence grant for allowance made to any such servant while under suspension. An expectancy of succession by survivorship or other merely contingent or possible right or interest, a right to future maintenance, any allowance declared by any Indian law to be exempt from liability to attachment or sale and execution of a decree, and where the judgment debtor is a person liable for the payment of land revenue, any movable property which under any law for the time being applicable to him is exempt from sale for the recovery of an area of such revenue. Wide notification number 8298J 42 of 489 dated 5th of January 1943, Punjab government has declared that the dearness allowance payable to any public officer serving the government in connection with the affairs of the state shall be exempted from the attachment of a decree. As per notification number 186/37 dated 2nd of October 1940, central government in pursuance of clause L of the proviso to subsection 1 of section 60 CPC has declared the following allowances payable to any public officer in the service of the said government or any servant of a federal railways or of a cantonment authority or of the part of port authority of a major port to be exempted from attachment by order of a court. All kind of traveling allowances, all kind of conveyance allowances, all allowances granted for meeting the cost of uniforms and rations, all allowances granted as compensation for higher cost of living in localities considered by government to be expensive localities, including hill stations, all house rent allowances, all allowances granted to provide relief against the increased cost of living, a foreign allowance, or in the case of heads diplomatic missions, Friesti representations assigned to officers serving in post abroad. Volume 1, Chapter 12, Part N, Rule 1 of Rules and Orders further specifies the property of agriculturist exempted from attachment and sale, which is as follows. the necessary wearing apparel, cooking vessels, beds and bedding of the judgment debtor, his wife and children, and such personal ornaments as in accordance with religious usage and cannot be parted with by any women. Section 60, subsection 1, clause A of the code, implements of husbandry and such cattle and seed grain as may, in the opinion of the court, be necessary to enable him to earn his livelihood as an agriculturist, and such portion of agriculturist produce or any class of agricultural produce as may have been declared by the state government to be free from liability under section 61, while also clause B of the proviso to section 60 subsection 1 of the code, where the judgment debtor is liable to pay land revenues so much of the produce of the land as the collector thinks necessary for seed grain and subsistence until the harvest next following of the judgment debtor, his family and cattle exempted under head B, section 70 of the Punjab Land Revenue Act with section 88 of Punjab Tenancy Act and section 60 subsection 1 clause P of the CPC. Under section 61 of the Civil Procedure Code, the Punjab government has declared that in case of agriculturists, the judgment debtor's entire fodder crops, including gram, oats, chari, maize and guara, 1/3 or 20 months, whichever is greater, of food grains and 1/3 of all other crops shall, subject to the provisions of clauses B and P of subsection 1 of section 60 of the CPC and of the proviso to section 70 of the Land Revenue Act, be exempted from liability to attachment or sale in the execution of a decree for the purpose of providing until the next harvest for the cultivation of land and for the support of the judgment debtor and his family, houses and other buildings with the materials and the sites thereof, and the land immediately appurtenant thereto and necessary for their enjoyment belonging to an agriculturist and not proved by the decree holder to have been let out on rent or lent to persons other than his father, mother, wife, son, daughter, daughter-in-law, brother, sister, or other dependents, or left vacant for a period of a year or more. Section 60, subsection 1, clause C of the code, and section 35 of Punjab Relief of Indebtedness Act as amended by Punjab Act 12 of 1940. Milch animals, whether in milk or in calf, kids animals used for the purpose of transport or draught cart or open spaces or enclosures belonging to an agriculturist and required for use in case of need for tying cattle, parking carts or stacking fodder or manure. Clause deemed to be added to the proviso to section 60 subsection 1 of the code by Act 12 of 1940. Standing crops except cotton and sugarcane, section 10 subsection 1 of the Punjab Debtors Protection Act. Standing trees apart from the land on which they stand cannot be sold, section 10 subsection 2 of the Punjab Debtors Protection Act. Note, if an execution application for executing a decree by way of attachment or attachment and sale is made after more than 2 years of the decree or against a legal representative of a party to the decree or against the assignee or receiver in insolvency where party has been declared as insolvent, the court shall issue notice to judgment debtor to show cause why execution should not be issued against him. Now, where the property to be attached is movable property in a decree for money, warrant of attachment has been ordered to be issued. Elmad or execution clerk shall issue warrant of attachment of movable property in a decree for money on proforma number 8, appendix E CPC, which is as follows. So we have also provided with the proforma number 8, which is warrant of attachment of movable property in execution of a decree for money under order 21 rule 30. So here in the title we have to give the title of the case, and this warrant is addressed to the bailiff of the court. So if we read the warrant, it says, whereas dash was ordered by a decree of this court passed on the dash day of dash in suit number dash of dash to pay to the plaintiff the sum of rupees dash as noted in the margin. So in this blank, we have to write the name of the judgment debtor or the defendant who was ordered by decree of this court passed on the day of. Here we have to write the date of the decision of the or the date of the decree. In suit number, the particulars of the suit to pay to the plaintiff the sum of rupees, the amount which is due against the plaintiff or the decree holder, as noted in the margin, and whereas the said sum of rupees dash, the sum which is yet to be paid by the judgment debtor or the defendant, has not been paid, these are to command you to attach the movable property of the said. Here in this blank, we have to write the name of the judgment debtor as set forth in the schedule here unto annexed, or which shall be pointed out to you by the said. Here we have to write the name of the decree holder, and unless the said, here we have to write the name of the judgment debtor shall pay to you the said sum of rupees dash. Here we have to write the amount together with rupees dash, the amount of cost, the cost of this attachment to hold the same until further orders from this court. So this is the schedule which is annexed with the warrant of attachment of the movable property, which includes the decree, the principal, interest, cost of execution, further interest, and total. You are further commanded to return this warrant on or before the dash day of dash, the particulars on which the warrant is to be returned by the bailiff, with an endorsement of certifying the day on which and manner in which it has been executed and or why it has not been executed, given under my hand and seal of the court, this dash day of dash. Here the particulars of the day on which the warrant is issued is given. Then there is a schedule, and then there is a signature of the presiding officer or the judge. Now, where the property to be attached is movable other than agricultural produce in the possession of JD, the attachment shall be made by actual seizure. Ailment or execution clerk shall issue warrant for seizure of specific movable property adjudged by a decree on pro forma number 9, Appendix E, CPC, which is as follows. So we have also again given the pro forma number 9, which speaks with regard to the warrant for seizure of specific movable property adjudged by decree under order 21, rule 31. Here we have to give the title of the case. The warrant is addressed to the bailiff of the court. And again, whereas dash was ordered, that is the name of the judgment debtor, by decree of this court passed on the dash day of dash. Here the particulars when the decree was passed by the court in suit number dash. Here the particulars of the suit as to when it was passed, the date of the decision or the decree, to deliver to the plaintiff the movable property or a dash share in the movable property. Here we have to write the share of the movable property which the plaintiff or the decree holder is entitled to, specified in the schedule here unto annexed, and whereas the said property or share has not been delivered, these are to command you to seize the said movable property or a dash share, the share which the plaintiff or decree holder is entitled to, we have to write here, of the said movable property, and to deliver it to the plaintiff or to such person as he may appoint in this behalf, given under my hand and the seal of the court, this dash day of dash 19/20. Here we have to write the date on which this warrant was issued. Then we have to annex the schedule, and then the signature of the judge is to be appended here. Then where the property to be attached is a debt not secured by a negotiable instrument, a share in the capital of the corporation, other movable property not in possession of judgment debtor, order of attachment has been passed prohibiting, in the case of the debt, the creditor from recovering the debt and the debtor from making payment until further order of the court. In the case of share, the person in whose name the share may be standing from transferring the same or receiving any dividend thereon. In the case of other movable property, the person in possession of the same from giving it over to the judgment debtor. Ailment or execution clerk shall issue order of attachment and pro forma number 16, 17, and 18, Appendix E, CPC, respectively. Pro forma number 16, 17, and 18, Appendix E, CPC are as follows. Now, pro forma number 16 says attachment and execution prohibitory order, where the property to be attached consists of movable property to which the defendant is entitled, subject to a lien or right of some other person to the immediate possession thereof, under order 21, rule 46. Here we have to write the title of the case. 2, whereas dash, here we have to write the name of the judgment debtor or the defendant has failed to satisfy a decree passed against dash. Here we have to write the name of the decree holder or the plaintiff on the dash day of dash So here we have to write the details of the date on which the decree was passed. In a suit number, here we have to write the details of the suit in favor of dash, the name of the plaintiff or the decree holder. For rupees dash, we have to write the amount which the decree holder is bound to be receiving from the judgment debtor. It is ordered that the defendant be and is hereby prohibited and restrained under the further order of this court from receiving from dash the following property in the possession of the said dash. Here we have to write the name of the person in whom the property is under possession. That is to say, dash to which the defendant is entitled subject to any claim of the said person under whom it is in possession, and the said dash is hereby prohibited and restrained until the further order of this court from delivering the said property to any person or persons whomsoever, given under my hand and the seal of the court, this dash day of dash. Here we have to write the date on which the said order or the warrants were issued. Similarly, is the attachment in execution prohibitory order where the property consists of debts not secured by negotiable instrument. The proforma is given under proforma number 17 under order 21 rule 46. Then the title of the case. Then this attachment is to be addressed to the person to whom the prohibitory order is being issued. Then we have to write the particulars in whereas dash has failed to satisfy a decree passed against dash on the dash day of dash in suit number dash of 19/20 in favor of dash for rupees dash. So here we have to write the name of the judgment debtor. There we have to write the name of the decree holder. Here we have to write the details of the date of the decree when the decree was passed. And here we have to write the particulars of the suit in which the decree was passed in favor of the name of the decree holder or the plaintiff for rupees the amount which is due against the decree holder. It is ordered that the defendant be and is hereby prohibited and restrained until the further order of this court from receiving from you a certain debt alleged now to be due from you to the said defendant, namely. So here the name of the judgment debtor is to be written here, and that you the said dash the person to whom this order is issued be and you are hereby prohibited and restrained until the further order of this court from making payment of the said debt or any part thereof to any person whomsoever or otherwise then to this court, given under my hand and the seal of the court, this dash day of dash 19/20. Here the sign of the judge is to be appended. Now coming to proforma number 18, which is attachment and execution of prohibitory order where a property consists of share in the capital of a corporation as under order 21 rule 46. In the title clause, we have to write the title of the case, to whom this attachment order is being issued, the defendant, and also the name of the person who is the secretary of the corporation. Again, the similar particulars are to be written that whereas dash the name of the judgment debtor or the defendant has failed to satisfy the decree passed against dash the name of the decree holder on the dash day of dash the details of the decree the day of the day on which the decree was passed in suit number dash here the particulars of the suit in which the decree of passed in favor of dash the name of the plaintiff or the decree holder for rupees dash the amount. It is ordered that you the defendant be and you are hereby prohibited and restrained until the further order of this court from making any transfer of dash number of shares. We have to write the number of shares here in the aforesaid corporation, namely the name of the corporation, or from receiving payments of any dividends thereon, and you dash the name of the secretary. The secretary of the said corporation are hereby prohibited and restrained from permitting any such transfer or making any such payment, given under my hand and the seal of the court this dash day of dash 19/20. Here we have to write here we have to append the signature of the judge, and here we have to write the dates, the particular dates on which this warrant was issued. Elmother execution clerk shall hand over the concerned attachment order in duplicate to the nazir. So it means that 2 copies are to be prepared of this attachment order. It shall be executed by affixing 1 copy on some conspicuous part of the courthouse and by sending another copy in case of debt to debtors, in case of share to the proper officer of the corporation, and in case of other movable property to the person in possession of the same. Now, where the property is a negotiable instrument, that is check, pronote, etc., and neither deposited in a court nor in the custody of a public officer, the attachment shall be made by actual seizure in case of such an order. Elmad or execution clerk shall issue order of attachment in pro forma number 20, appendix E CPC, which is as follows. Again, we have given you the pro forma number 20, which is the order of attachment of negotiable instrument under order 21, rule 51. So here we have the title of the case. This order of attachment is addressed to the bailiff of the court, and it says that whereas an order has been passed by this court on the dash day of dash. So here we have to write the particulars of the particular date of the order for the attachment of dash. The here we have to write the particulars of the negotiable instrument which is liable to be attached. You are hereby directed to seize the name of the negotiable instrument and bring the same into court, given under my hand and seal of the court this dash day of dash. So here we have to give the details of the date on which this order of attachment was issued, along with the signature of the presiding officer or the judge. Now, where the property to be attached is property consisting of money or of any security in the custody of a court of justice or public officer, order of attachment shall be made by a notice through such court or officer requesting that such property and any interest or dividend payable thereon may be held subject to further orders of the court. In case of such order, Elmad or execution clerk shall issue order of attachment and pro forma number 21, appendix E CPC, which is as follows. Again, we have provided you with the pro forma number 21, which is a prohibitory order where the property consists of money or of any security in the custody of a court of justice or public officer. Order 21, rule 52. Again, we have to give the title of the case to here we will write the name of the persons to whom this prohibitory order is issued, and it says that, sir, the plaintiff having applied under rule 52 of order 21 of the code of civil procedure 1908 for an attachment of certain money now in your hands, here state how the money is supposed to be in the hand of the person addressed and on the what account, etc. I request that you will hold the said money subject to the further order of this court. I have the honor to be, sir, your most obedient servant, dated dash the day of the particulars on which this prohibitory order was issued and the signature of the judge. Now, where the property to be attached is a decree passed by some other court on order of attachment, order 21, rule 53 CPC, Elmad or execution clerk shall issue notice of attachment of a decree to the court which passed it and notice of attachment of a decree to the holder of the decree as ordered on pro forma number 22 and 23, appendix E CPC, which are as follows. So we have provided you with the pro forma number 22, which is notice of attachment of a decree to the court which passed it, order 21, rule 53. Again, we have to write the title of the case. This notice of attachment is issued to the judge of the court who had passed the decree. And it says, sir, I have the honor to inform you that the decree obtained in your court on the dash day. Here we have to write the details of the decree on which it was passed, the day on which it was passed by the plain defendant or the judgment debtor in suit number. Here we have to write the detail of the suit number in which the decree was passed, in which he was we have to write the particular as to whether the judgment debtor was defendant or was plaintiff, who was he before in that suit, and was and has been attached by this court on the application of the. Here we have to write the name of the decree holder or the plaintiff who had moved the application to the present court for the attachment. In the suit specified above, you are therefore requested to stay the execution of the decree of your court until you receive an intimation from this court that the present notice has been cancelled, or until the execution of the said decree is applied or for by the holder of the decree now sought to be executed or by his judgment debtor. I have the honor, etc. Judge. Here the signature of the judge is to be appended and the date on which this said notice has been issued by the court. Similarly, is pro forma number 23, which is given under order 21, rule 53 about the notice of attachment of a decree to the holder of the decree. So again, we have to give the title And then 2, whereas an application has been made in this court by the decree holder in the above suit for the attachment of a decree obtained by you on dash, the particulars of the decree has to be given in the court of in suit number, the particulars of the case and the particulars of the court in which the decree was passed, in which we have to write the particulars of the particulars and specification of the decree holder in the present case and judgment debtor in the present case as they were in that case in which the decree was passed. It is ordered that you, the said, here the name of the person in possession of whom the decree is, be and you are hereby prohibited and restrained until the further order of this court from transferring or charging the same in any way, given under my hand and seal of the court this day dash of 19/20 dash judge. So we have to give the particulars on which this notice was issued along with the signature of the judge. So these are the important performers and certain aspects so far the attachment and sale is concerned. In the next video, we shall be looking into the custody aspect and the disposal aspect of the attached movable property pending sale. So till then, namaskar.